Thank you. Today we're watching and learning about VAWA 2023, the Violence Against Women's Act. And if you could go on to the next slide, that'd be great. Thank you. So what is VAWA? VAWA is the Violence Against Women's Act. It's a law that protects survivors and individuals threatened with domestic violence, dating violence, sexual assault, and stalking from being discriminated against by certain housing providers because of the violence committed against them. There's eligibility, and to be eligible for VAWA protections, an applicant and tenants of HUD housing programs who are victims of domestic violence, dating violence, sexual assault, or stalking. It's not limited to women and available to all without regard to sex, gender identity, or sexual orientation. There are not eligible for VAWA protections. Your guests aren't eligible, unassisted household members and live-in aides are not eligible for protections. It's limited to the tenants. As a side note, though, as a reasonable accommodation, a tenant can request VAWA protections if a live-in aide is a victim and may request an emergency transfer for the household. Individuals and families who rent from private landlords who receive no federal assistance, again, are not eligible for VAWA protections. There are several HUD programs covered under VAWA, the 2013. There's the HUD programs assisted under the United States Housing Act of 1937, specifically public housing under Section 9 of the 1937 Act, tenant-based and project-based rental assistance under Section 8 of the 1937 Act, and the Section 8 moderate rehab single room occupancy. We call that the HUD HCV, tenant-based and project-based. There's also Section 202, supportive housing for the elderly, Section 811, supportive housing for persons with disability. There's housing opportunities for persons with AIDS, HOPWA, home investment partnerships, the HOME program, and we have homeless programs under the Title IV of the McKinney-Vento Homeless Act, including the Emergency Solutions Grants, the Continuum of Care program, and the Rural Housing Stability Assistance Program. We also have multiple multifamily rental housing under Section 221 of the National Housing Act, with a below market interest rate pursuant to Section 221 D5. Multifamily rental housing under Section 236 of the National Fair Housing Act, National Housing Act, I should say, and the Housing Trust Fund. VAWA covers low income tax, housing tax credits, certain USDA and VA housing programs. VAWA 2022 added the direct loan program under Section 202 of the Housing Act of 1959 and the Housing Trust Fund, previously only regulatory. VAWA 2022 adds a provision for any other federal housing programs providing affordable housing to low and moderate income persons by means of restricted rents or rental assistance, or more generally providing affordable housing opportunities as identified by the appropriate agency through regulations, notices, and any other means. This is pretty much a catch-all, that last one. There's some VAWA housing protections. It was enacted in 1994 and amended multiple times. HUD's regulation for VAWA protections, rights, and responsibilities are codified in 24 CFR Part 5, Subpart L, and related provisions in HUD's program regulations, the HUD's VAWA regulations. These regulations implement VAWA as amended through VAWA 2023. The VAWA Reauthorization Act of 2022 was included as part of the Consolidated Appropriations Act of 2022. The amendments that VAWA 2022 makes to the Housing Rights Chapter of VAWA build on 2013 and 2016 amendments to strengthen VAWA's housing protections for victims of violence, dating violence, sexual assault, or stalking. HUD programs may not deny or terminate applicant tenant assistance or tenancy on the basis or as a direct result of the applicant or tenant currently or having been a victim of VAWA or its occupancy. Being denied admission to rental housing, this is one of VAWA's protections. The rental housing, either federal rental assistance just because I'm a survivor, being evicted, or losing federal rental assistance because I am a survivor or threatened with violence, being denied admission or rental assistance, evicted, or losing a subsidy for the reason related to the abuse, such as bad credit, rental history, or criminal history, retaliation for asserting VAWA rights, the right for anyone, not just survivors, to call 911 or the police for help. And how do I prove I can use VAWA protections? The housing provider may ask for documentation showing that you are a survivor. The housing provider must make this request in writing, and there are 4 ways to show that you're a survivor. The first is a self-certification form, the HUD 5382, and this was included in the email sent out with the webinar. And the form asks for your name of the abuser, if that's known, and the abuser's relationship to you, the date and time of the place of the violence, and its description. And the second way is a letter signed by a victim service provider, such as a domestic violence or sexual violence counselor, attorney, or a medical or mental health professional who has helped with the violence. You must also sign this letter. A police report, a court order, such as a restraining order or administrative record, is the third way. And the fourth way is a statement or other evidence, if accepted by your housing provider, such as an email, text message, or social media posts. You can choose any of these options. Unless the perpetrator also produces similar proof, the housing provider cannot make you choose a specific type of proof or more than one type. The housing provider must give you at least 14 business days. Weekends and holidays aren't included to provide this proof. So what's new? Well, let's see. The HUD's press release, February 2023, HUD announced new resources for advancing housing protections for survivors of domestic violence, dating violence, sexual assault, and stalking. HUD also, FHEO 2023 in January, is the notice to public regarding the enforcement authority and procedures of the Violence Against Women's Act 2022. And HUD and the FHEO memo guidance on the implementation of the FHEO notice was also out March 27th, 2023. And then we have the HUD Federal Register Notice, the Violence Against Women's Act of 2022 in January of 2023. That's a proposed rule. And HUD has a website just for VAWA now, and the website is listed above, and this is what it'll look like when you go to the website. There's VAWA enforcement. The Secretary of Housing and Urban Development and the Attorney General shall implement and enforce this chapter consistent with and in a manner that provides the rights and remedies provided for in the Fair Housing Act. So what happens if the abuser also submits a certification claiming that they are a victim? So if this happens, the provider receives proof from the alleged perpetrator claiming that they are the victim, then the provider may require you to submit additional proof. Does this mean I cannot be evicted at all? No, you can still be evicted for serious or repeated lease violations that aren't related to the abuse. The housing provider must hold you to the same standards as other tenants. And the housing provider may evict if there is a real and immediate threat to other tenants or staff if they aren't evicted. If you are threatened with eviction, call legal aid immediately. Here's a list of resources that are available, and I believe we've included the handouts and the slides in today's email. If you have any questions about these resources, please let us know.
Are you seeing that new
Okay.
slide, Tiffany?
Yes, thank you.
Okay. Okay.
So we're going to jump into a scenario because sometimes it's good to have what ifs. Jerry, who is 64 years old, and Sarah, who is 58 years old, are a household and live in a Section 202 elderly property. Jerry, who is the head of household and program qualifying household member, receives zero income and an elderly deduction. After an altercation, Sarah claims VAWA protections. Jerry moves out of the unit and leaves Sarah as the sole household member. The management agent intends to bifurcate the lease as long as Sarah can establish eligibility. Sarah's rent increases because the household no longer receives the elderly deduction. Can Sarah remain in the unit and become the head of household? And how will her tenant payment be determined? In project-based, Sarah must meet program eligibility requirements within 90 calendar days or when the lease expires, whichever comes first. If eligibility cannot be established, the individual may remain in the unit but must pay the contract rent. If eligibility is established, the tenant payment will be based on the remaining family member's income. For Section 202, Sarah is 58. She does not meet the program eligibility requirements. Therefore, she must vacate the unit within 90 calendar days or when the lease expires, whichever comes first. Sarah is not eligible to receive subsidy and must pay market rate for the duration of tenancy. When a resident requests VAWA protections, can an apartment manager require the applicant or tenant to obtain a restraining order as documentation of the victim's status? No, the apartment manager cannot require the tenant to obtain a restraining order as a way to document victim status. When requesting documentation of the victim status or an incident of VAWA, management must accept any of the types of documentation listed in the VAWA certification form, HUD 5282. The head of household is a victim of domestic violence, but continues to let the abuser, who is not a member of the household, in the unit. The couple's repeated altercations disrupt other tenants. And the head of household has claimed VAWA protections, but has refused to move forward with any charges and maintains a relationship with the abuser. Does the head of household still have the same rights under VAWA? Yes. Apartment management cannot penalize a VAWA victim based on the fact that the victim still has a relationship with the abuser. However, VAWA doesn't limit the authority of an apartment manager to evict a tenant if the apartment manager can demonstrate that an actual and imminent threat to other tenants or those employed at or providing services at the property would be present if the tenant or lawful occupant is not evicted or terminated from assistance. A project-based resident obtained a restraining order against a relative who is not a household member. The relative continues to steal from the resident and brings unwanted guests into the residence unit. The resident is hesitant to pursue further charges and has not requested VAWA protections. How should the apartment manager address the resident's circumstances? Well, whenever an apartment manager is notified of a court order, management has authority to comply with such order to protect a victim of VAWA. In this case, management can refuse access to the property. Management can also remind the resident of available VAWA protections and resources, such as an emergency transfer to a safe unit. Are we be required to maintain documentation of VAWA claims in a file separate from tenant leasing files. Yes, the VAWA rule does not require VAWA documentation to be maintained in a specific location. However, HUD's VAWA regulation restricts disclosure of VAWA information to individuals other than the victim unless special conditions are met. Apartment managers must not enter confidential information into any shared database. This is because domestic violence often occurs within the household, and the members of the household can review the tenant file. The regulation calls for confidential record keeping in a location other than the tenant file. The requirement is also stated in the HUD's Occupancy Handbook of 4350.3. The handbook requires management to retain all documentation relating to an individual's experience with VAWA in a separate file that is kept in a separate secure location from other tenant files. So if you think your VAWA rights have been violated, you can file a complaint with HUD. You can do this with or without an attorney. You can also, for more information on your rights under VAWA or to file a complaint, you can go to HUD's new VAWA website, which we showed earlier. Do we want to do some polls now?
That's right. Let me real quick remember how to do that. Sorry.
So
we were just practicing it. Okay, here we go.
Yes. So we're going to do some polls now. This is anonymous. So only way anybody's going to find out is if you tell on yourself. These are anonymous. So please join in the fun. Sean applied for assistance as a project-based Section 8 property and was notified by an apartment manager that the application was denied due to poor rental history, as he was previously evicted 2 times. Sean informed the apartment manager the eviction stemmed from criminal activity engaged by an abusive partner that is no longer a household member and provides documentation to support the claim. So below you have 3 choices. So I'd like you to choose which one you think is the correct scenario. And we'll give you like a minute. Okay, it looks like we're still getting some polls going here. And it looks like the majority are saying the apartment manager should approve Sean for the unit. And I believe that is the correct answer. Does it say that in our poll?
I don't have access to the answer.
Okay.
We have some other questions. People are reading ahead. They're so good.
They are. Okay. So yes, the apartment manager should approve Sean for the unit in providing the documentation for VAWA. Our second one, a tenant has been found by their perpetrator. Can the tenant move to another property? And if there's another building the tenant can move to, then yes, they can move to another project-based building or get on a waiting list. So the first one on number 2 is correct. Oh, our answers are down below. Oh, no, they're not. Okay, so in number 3, a tenant is in a project-based unit and has found and no other unit is available with the project. Can the tenant request a tenant-based voucher? Yes, the tenant can request a tenant-based voucher and be put on a waiting list if there aren't any available to issue. And that's it for our polls. Would
Oh,
we like to
sure.
go to?
There we go. Listen, this is the second time we've done polls,
I
and
know.
we're getting better.
Yes. Yes.
So I do think, thank you, Tiffany, for all of that information. I do think with VAWA, it's going to be based off of questions that we get from our agencies as well. VAWA is very expansive. It applies to a lot of things, but we are the housers. And so what we know is what it means for housing people, and particularly housing people with housing choice vouchers. So we are happy to take questions, which I see a couple coming in. And I'm going to stop sharing this poll. There we go. So the first question is, if we get the VAWA paperwork and it is approved, do we still need to get a mutual rescission of the lease? So my answer to that, and this is Catherine, and I don't know if you want to see my face, but here I am. No, wait, you still can't see me. Here I am. Sorry. No, so VAWA is twofold here in this situation. We're the housing authority, so we can manage the voucher. The landlord is the property owner, the property manager. I can't control whether or not the landlord properly follows the VAWA guidelines. I know they have to because they're a recipient of federal housing funds, but I can't enforce that. I can't enforce anything in the lease because I didn't sign the lease as a housing authority. As the housing authority, it's my responsibility if somebody provides the proper documentation and says I need to leave this unit because I'm invoking my VAWA protection. Here's all the documentation, we approve it. I don't need a mutual rescission of lease. I know this person needs to move for their safety and I'm going to approve it. Now, could the landlord come back and say they didn't provide me with the right VAWA, I'm going to move to eviction? I know that happens. And so in those cases, we're not going to terminate the person because we got what we needed on our end, but we are going to encourage the tenant to seek out legal representation to help them with their landlord on that side of it. We get a lot of questions from landlords. You allowed this person to move. I don't have anything that shows that they have these protections. I can't share that with the landlord. The tenant needs to also do that piece with the landlord, either with representation, with assistance from a service provider, from legal aid, from a domestic violence program counselor, anything like that. But we aren't going to punish them. That's a word, terrible word. We're not going to take action like we would if a participant was evicted for other reasons that weren't related to them having to move out of the unit because of domestic violence. I hope that answers that question. The next question says, in the admin plan, waitlist preference says applicant must be currently experiencing domestic violence resulting in a need for housing. What is the definition of currently? So our waitlist preference and VAWA are two different things. I'll start there. Also, if verification of preference must be in the applicant file, but VAWA issues need to not be in the applicant file, how should this be addressed? Two very good questions, Rose. So first, we do offer a preference for people currently experiencing domestic violence. And our definition of currently experiencing domestic violence is there's an immediate need today for them to leave the situation they're in. They can't because they can't afford to leave the situation they're in. They need a voucher to do so. That is what we mean for our domestic violence preference on the housing choice voucher waitlist. And so VAWA, now we can use that 5382, the 5382 certification form as one way to document that preference. But you're right, should that be in their file if we are saying that anyone in the household could have access to that file? And we know that oftentimes the perpetrator of the domestic violence is still in the unit or still in the household. So I think we need to look into how we address that preference and how we manage that documentation. So stay tuned. I'll look into that and provide a follow-up. And I'm going to write that down right here. But we do offer domestic violence preference as a result of the Violence Against Women Act legislation back in 2013. It was encouraged that one step that housing authorities could take to assist in the legislation was to offer a preference. Okay, question. I understand the landlord must keep VAWA info separately, but what about our DOH voucher file? Again, good question. Can we include the VAWA documentation in the file? I think what we learned from the what's new, and if we looked back a couple slides, VAWA's been a law since 2013. It has been reauthorized throughout the years. Some years it was questionable whether it would be reauthorized or not. Fortunately, it has been reauthorized. What was recently in 2023, all the things that are new with VAWA aren't the protections necessarily, but what happens if a participant, a tenant, an individual alleges that they were not treated fairly or they did not get the VAWA protection they were eligible for. There weren't really teeth with the law. There wasn't a place for participants, tenants to file a complaint, to say, hey, I provided what I needed to my housing authority, to my landlord, to the property manager, and nobody did anything. And so my rights as an eligible person protected by VAWA were violated. So now we have this opportunity, our participants have this opportunity, or tenants, anyone in a rental program, anyone receiving federal rental assistance has the opportunity to file a complaint with HUD's Fair Housing and Equal Opportunity Office. And what we've also learned through this new information in 2023, and maybe it was old information, but what's brought to our attention is we need to keep this separate. It should not be in the regular housing file. And so I think what we are tasked with at DOH is to provide additional guidance on what that might look like. Do you have a separate locked file for the documentation you receive? Now, a person could select domestic violence as a preference on their application. I think that's okay, but whatever you collect to verify that preference will likely need to be in a locked cabinet somewhere else or in a separate folder, digital file not attached to their tenant file. So we're going to have to come up with some guidance on what that looks like. I will go back to our, with the new hosting change that's taking place that I mentioned before we started recording. Some of you may not have been logged in. Our data will be hosted on a new site soon. We're in the process of testing. And so when we move over to the emphasis environment for hosting, we will have an opportunity to make all of our files digital, and they are attached to the record in Elite. We do have that option now, but our existing host, the Department of Human Services, they just don't have that storage available, right? Because we're getting a free product from them. So we are paying for this license for people to have access to our new hosting site. And with that, in the future, again, these are baby steps that we're taking, we'll have this opportunity for digital files. And there could also be an opportunity for a separate digital file where we can save this confidential protected information about domestic violence preference, about VAWA protections, about you know, the CBIs that we run, or the NSOPW data that we might have printed out that should be separate. These are all good questions coming with our new host. So exactly, so if the file is selected for a HUD audit or for CMAP audit, some of you have heard from me recently because of some CMAP sampling that we had to do. I think there has to be some sort of indicator in your file, again, guidance forthcoming, that would say, you know, just to remind you that the backup documentation that is being asked for to support that preference of domestic violence is located in secure location G or wherever it's saved. I think there needs to be some kind of notice so that you can go and access that, because HUD, the HUD auditors will want to see it. but if it's confidential information, should we be sharing it? Again, I need to dig into that. We have to be very careful with VAWA and domestic violence. And I don't have to say it, or I do have to say it. People who are victims of domestic violence, oftentimes their perpetrators are very clever and know how to access information about them, where they are, personal information about them. So we need to be careful with who we share that with. So again, these are excellent points that I think we need to dig into that VAWA legislation and see what our requirements are at the PHA level and at your level on keeping that data protected. Great question, Melinda. I think it goes along with what I need to dig into a little more. If we have to go back through the files and take that VAWA paperwork out, or the domestic violence preference support documentation, if it needs to be removed. So we would be able to help, at least with the preference. We can tell what preference people had when they leased up. Of course, that's one of our CMAP requests that has gone out to everyone who was selected. So we could probably, when the time comes, provide you with that list of, hey, these are probably the files you'll want to look in. And how do we indicate the action with documentation of the action to remove a household member or make an emergency move? I think we could use the note function that just said, well, I mean, for a move, I mean, it's an emergency move, but as a, sorry if that just popped up. My core session is expiring. Sorry about that. With the Housing Choice Voucher Program, an emergency move isn't really an emergency move. They have the right to move with their voucher. We don't have a policy at the Division of Housing that someone can only move once a year or something like that. I know the case is, well, the landlord hasn't approved them to break the lease. So we could, put a note to file that says DOH approved, this move without landlord documentation or something along those lines. Again, I think what's critical that we don't want in the file are personal details about a person's domestic violence experience, who's helping them, what are they receiving assistance from an agency? We don't want any direction to where this person is getting help, where this person could be, where this person has transferred to. I mean, we have that information in Elite, but we're not, if we have all that documentation that's really specific personal information, that's what we want to keep separate. If we say someone had a domestic violence preference or someone moved because of VAWA, I think that's maybe a little different, as long as it's not indicating additional information. I got to get more information before I have a final answer to that. Let's see. Yeah, Melinda, that's a good point. If we have reviewed all the documentation you've sent us, I think we do this with medical expenses too. Oftentimes there's a lot of medical expenses. It's very specific. We could probably determine what somebody's, diagnosis is based on the medical documentation that they've provided to us. So if we just certify, we saw everything, this is the amount for medical expenses, then we are okay with all of those receipts and such not being in the file. I think that's been our guidance in the past. We could follow a similar process here where you've provided us with everything, we've reviewed it, we've signed off and said we've reviewed everything based on what was provided. This is an approved move, this is an approved addition, this is an approved transfer. And that should be sufficient. We have to have a policy. It has to be in our admin plan, so that should HUD or the state auditor audit us, we can say, hey, we don't have that stuff, and here's why our policy says we wouldn't have it. Our policy says we have the certification form in place of. That's a great point, Melinda. And I'm writing it down. Any other questions? I think the guidance we've given about VAWA in the past is that we are not the experts. We are not attorneys. Maybe some of us are. I'm not. And so what I don't want is to do the wrong thing. And so if we have a very specific situation that we're just not sure how to handle, if we don't feel like we have the right documentation to support somebody's request to, for example, they're in a project-based unit, they haven't been there for a year yet, but because of a VAWA situation, they would feel safe and it's in their best interest to move out of that project. Generally speaking, they wouldn't be eligible for a tenant-based voucher if they haven't been there for a year. But in a situation with VAWA, they would, or they might be. And so if we want to make sure we're allowing people to be safe, but we also want to make sure we are getting the proper documentation, following the proper process to do so. And so we need to look into our processes. But again, historically, VAWA in terms of housing choice voucher is we are allowing people to move, even if a landlord's digging in their heels and saying, you don't know it, this isn't domestic violence, they're just saying that. But if we have what we need based on what the legislation asks of us, we're not going to not allow somebody to move. An HCV voucher is a choice voucher. Nobody, they're not in a public housing where the assistance is just for the unit. Our project-based vouchers, we do have some leeway. Of course, being in a budget shortfall, we don't have the funding, but we can allow someone to get on a waiting list for a voucher in those situations. We're a little bit limited because the Housing Choice Voucher Program doesn't have quite the same options because the very nature of the voucher is that it's portable. So a person can port right out of state without jumping through a ton of hoops anyway. But with VAWA, we can get it done maybe a little bit quicker. Question, does the request for reasonable accommodation due to domestic violence have a different form than the reasonable accommodation due to disability? Is the form included in the email sent prior to this webinar? So domestic violence protections and reasonable accommodation requests are two different things. A reasonable accommodation request is a request for somebody who has a disability that we make a change in our policy or process so that they can equally access our program. A person experiencing domestic violence isn't necessarily a person with a disability. So those two are exclusive from each other. We do have the certification form 5382 that was sent in today's email. It is on our website. It is in our briefing packet, and it is provided anytime a negative action is taken. If we're terminating somebody, if we're denying somebody a request, when they get that letter, we have the notification of VAWA protection and the request for reasonable accommodation. They kind of go together. So it's the HUD certification 5382. It does say it expired in 2017. Disregard that. HUD hasn't provided a new form since 2017. So until they do, that form is still valid. So that's the form that's one option to be used. Again, Tiffany provided 4 options for ways that a domestic violence situation can be documented. That certification form is one of them, but sometimes it's the easiest one for them to use. But we could also accept police reports, restraining orders, a letter or a note or something from a provider who can verify that this person, is working with us. We can attest, and even social media posts, things that are somebody's threatening or sending threatening emails or text messages. This is not a black and white subject. We know that it looks different for everybody. We know that not everyone feels comfortable going to the police or filing a restraining order. We know that some people are currently with the person who is the abuser or the perpetrator, and they're not quite ready to leave. There isn't one right answer, and I think that's why HUD allows so many different ways for it to be documented. Any other questions about VAWA and our programs? We do have on the resource page, I think, chapter 10, and I guess I can go back. Let's see, chapter 10. here we go. Chapter 10 and chapter 16 in our admin plan really spells out our approach to how we will handle VAWA scenarios and situations. And so I would encourage you to look there. And then again, we've offered some other places where HUD has discussed how VAWA impacts their different programs, if you are interested in learning more. And then again, just like with a reasonable accommodation request or termination request, we're not asking you to be the experts on whether or not somebody has provided enough documentation for a VAWA request. Do send all of those questions to your SPOCs. It's our goal to do the right thing. We aren't the experts. We know the experts, and we know when to ask for their help in situations that don't seem clear to us. And so we want to make sure we're doing everything correctly, because this is federal legislation and it's people's safety. So it's important that we're doing this correctly. And it's a 10-year-old law that I still feel like I don't understand. And so any opportunity that I have to understand it more, like Tiffany offering to do this webinar, which is awesome, we will take it. All right. Well, if there are no further questions, we can end this webinar. I will say our training committee is working on a survey that we will be sending out to everyone to get an idea of future trainings, topics, formats, what you guys want to see. So once we have that survey ready to go, we would really appreciate all of your feedback. We do our monthly webinar. We've done it this way forever. And I know sometimes we need something a little fresh and new, ways to do trainings that aren't, the 1 or 2 hour once a month session. So again, once you see that survey, we really appreciate if you could take, less than 5 minutes probably, to fill it out to give us some guidance. But with that, we will end this webinar. I don't see any further questions. Thank you to Tiffany for today's presentation, and you will be hearing from us soon. Bye, everyone.